Good morning, everybody. Welcome to the final session in our Field Fisher Brexit webinar series. This session, excuse me for 1 second. This session is on state aid and public procurement post-Brexit. For those that have been following this series, it follows a kind of long list of topics which we've covered over the last couple of months. In terms of what we're going to cover, this is sort of familiar, if you've been on these things before, a familiar list of questions. Where are we now? What comes next? What does it mean for me? What should I be doing? And any questions. I'm doing this presentation with John Castles, who's another partner in the regulatory team. I'm going to be doing the introductory bit and then talking about public procurement, and then we'll sort of hand over to John on the state aid side of things when we come to that. So where are we now? Here's a sort of diagram just sort of setting out the probably very familiar process that we are in terms of Brexit. We're obviously in the transition period, the UK having formally left the EU institutions in January this year. During the transition period, we have had effectively business as usual as far as the application of EU law is concerned. The UK has remained subject to EU law, although obviously with no kind of voice or influence over it while we're in this period. Negotiations have obviously been going on, as I'm sure everyone will be aware, between the UK and the EU as to the future relationship. And we are moving into, as this series is known, to the end game, and clearly there's still quite a bit of brinkmanship going on with regards to a future free trade agreement, and I guess nobody really knows at this stage what shape, if any, that's going to take. So as of the 1st of January 2021, the transition will end, and there'll either be a new relationship based on a new free trade agreement, or if there is no deal, it'll be so-called WTO terms. From the domestic legislation point of view, the withdrawal legislation, the European Union Withdrawal Act 2018, which has been amended various times since then, will come fully in force. And I'm sure those who've been sort of following the kind of legal process of Brexit will be aware that the effect of that act is effectively to sort of incorporate into the UK legal system the entirety of EU law, and then powers are given to the government to chop bits away that are no longer appropriate or relevant to the UK with its sort of its fully independent status outside the EU. So, sorry, what next? Well, I've just touched on this a bit. So either we have no deal, which means that trade with the EU will continue and third countries on so-called WTO terms, except where the UK has already reached a bilateral trading agreement, for example, with Japan. Apologies. Alternatively, and probably hopefully, the UK and the EU will reach a free trade agreement. I suppose sort of everyone's probably fairly familiar that it's likely to be, if there is an agreement, it's likely to be of relatively limited scope, probably covering just goods, little on agreement, little on services, and other sort of areas. And then the third possibility, which I think is extremely remote, is an extension of the transition period. So how does public procurement and state aid fit into all this? On the subject of public procurement, I think the position has been recently kind of clarified in these draft public procurement exit regulations, which were published on the 14th of October. Again, there are a lot of these EU exit regulations sitting around in draft, and some of them have been amended over the years and have not have had to deal with different eventualities. These regulations appear to be the final UK government's final position on public procurement, and I think the kind of headline message is that the government is taking the view that the EU procurement rules will, in substance, simply roll forward from the 1st of January 2021. So the regulations really do just some tidying up exercise. They amend and remove inoperable or inappropriate provisions, such as references to the EU institutions or notifications to the Commission. For example, they give UK ministers the power to set the thresholds for the application of the regulations, which previously had been the preserve of the European Commission. That sort of kind of mechanical institutional thing has been updated, or will be updated in the public contracts regulations so that they will work in a purely domestic context. Probably the most important kind of practical consequence is that publication of notices in the official journal will obviously cease as UK authorities cease to be member state authorities for the purposes of the OJEU, and replaced with publication in the so-called UK e-notification service, which the government is calling the Finder Tender service. So I predict that notices which used to be called OJEU notices will now be called FAT notices. And otherwise, there's little in the way of substantive change to the procurement rules. Similar amendments have been made to the concession contracts regulations, the utilities contracts regulations. And an important question, I think, that is going to sort of develop over time after the 1st of January is what happens to the EU case law on which has been used, obviously used to interpret the public contracts regulations and the underlying EU procurement directive. I think the effect of the EU Withdrawal Act 2018 is that EU case law on procurement will probably mostly remain applicable, and certainly it will be referred to by the courts in the event of challenges, but there will be more scope for the courts, so certainly the Court of Appeal and the Supreme Court, to depart from EU case law on procurement. So I think as the sort of new landscape beds in, certainly in the area of kind of litigation and challenges, we'll start to see more arguments over whether this or that principle in the EU case law is applicable, and if it is, whether it should be retained for the UK domestic purposes. Secondly, on procurement, and very importantly, it was the policy of the May government to join the government procurement agreement of the WTO, and an application was made a couple of years ago, originally under the May government, to join the government procurement agreement. The government procurement agreement of the WTO is effectively a sort of an agreement amongst certain member states of the WTO to open up their government procurement markets to each other within certain sort of specified areas that are defined in the schedules to the agreement. The UK has been a member of the WTO through its membership of the EU since the 1990s when it was set up, but hasn't had independent membership of the GPA. The GPA contains a procurement regime which is actually in lots of ways very similar to the EU procurement regime, and indeed the EU procurement directives are specifically designed to implement the EU's obligations under the GPA. So I think there was some uncertainty since the election last year whether the Johnson government would continue with the policy of joining the GPA, but it now seems that it has continued with that policy, and the UK will accede to the GPA from January 2021, 1 January, and that's been agreed by the other members of the GPA. And what that means in practice is that the duties that contracting authorities in the UK owe to UK economic operators under the procurement rules, in other words, obviously to comply with the relevant regulations, to behave in a sort of a proportionate and equal and non-discriminatory way, those will be extended to economic operators from other GPA states, which will include all EU member states and also other states which are also members of the GPA, such as the US, Canada, Australia, and so on. So in that respect, the duties of authorities will not change, and the rights of economic operators who are from GPA countries will remain the same for under the new rules in the GPA. And equally, the government was trumpeting the access that UK businesses will continue to have to, I think, 1.3 trillion. They said 1.3 trillion pounds worth of sort of public contracts in other GPA states, but effectively that just preserves the current position that UK operators have under the EU rules and the EU's access to the GPA. I think probably the most significant and substantive change that this new arrangement will lead to is that under the GPA, the rights of economic operators are limited to the scope of the goods and services that are sort of within the schedules specified in the GPA. Now, the EU schedule, which the UK has adopted, covers effectively all goods, but it has a narrower scope in relation to the procurement of services. So it covers what would be equivalent to the old Part A services, so things like computer services, consultancy services, but not the kind of full range of services that the current EU rules and the pre-Brexit UK procurement rules covered. And in practice, that means that services such as health, social care, legal services, those things which were used to be known as Part A and are now covered by what's known as the light touch regime in the procurement rules, those will be out of scope so far as non-UK operators are concerned. And that will afford, I think, authorities some ability or greater ability than they have now to limit tenders for, say, health services to UK-only operators. There is some interaction here with the trade bill, which is currently going through Parliament. What the government is trying to do with the amendments to the public contracts regulations through these exit regulations I mentioned on the previous slide is to preserve the current position. There's a trade bill currently going through Parliament, which is going to empower ministers to implement trade agreements that the UK is planning to enter into. So but that hasn't actually become law yet. So in due course, the intention is to effectively replace or update what we have in the public contracts regulations with new rules that will reflect whatever new trading arrangements the UK has agreed, either with the EU or with other countries under the trade bill. So they put in the EU exit regulations for procurement a 12-month window. So these rules in relation to GPA operators apply for 12 months. But the intention is not just that they come to an end at the end of 12 months, but they are simply updated in the light of whatever has happened in relation to the UK's trade agreements in the meantime and the powers under the new trade bill. So that's that's really what's going to happen in public procurement. I think the message is the procurement rules will remain in place in more or less unchanged form, with obviously new notification arrangements. On that note, I will hand over to John to talk about what comes next on state aid.
Thank you, Nick. Good morning, everyone. So, as Nick said, I'm going to cover the position on state aid, which, as will become clear, is quite unclear. So the Brexit negotiations and the position on state aid has been quite fractious, let's say, and there's been lots of press speculation about what will happen with the state aid rules and will state aid be a block to a free trade agreement. And just to be clear, by state aid rules, we mean the rules that are in place within the European Union to ensure that member states don't divert public funds to distort competition effectively. So they sit sort of alongside the competition law rules, but also they're the other side of the coin to the public procurement rules, in the sense that generally a well-run public procurement process is a good way of minimizing the risk that a contracting authority is going to be giving unlawful state aid. So that's where the state aid rule sits. And really the substance of the division, if you like, between the UK and the European Union on state aid boils down to two things, and those two things are, what will the rules be, and who will oversee and enforce those rules. That's the essence of it. There's as in everything, there's a sort of a sidetrack into the Irish protocol and the agreement with Northern Ireland, and the sort of convoluted positioning that the UK got itself into in order to ensure that there wasn't a hard border between Northern Ireland and the Irish Republic, but that the UK still remained a sort of a sovereign entity, which has proved to be quite a difficult thing to achieve, actually. And so, as Nick said, there are lots of EU exit regulations, and the same applies in state aid. So there are these draft state aid revocation and amendments regulations, and those are the regulations that effectively will apply in a no-deal scenario. So what those regulations effectively say is all of EU state aid law will be repealed, and all Commission state aid decisions will no longer be valid. And what that means in practice, I think, is somewhat up for debate. Nick and I were talking about this yesterday and just talking through. So if we think about state aid law, there are lots and lots and lots of state aid decisions. So in the energy sector, in financial services, in broadband, and a lot of those notified aid and cleared aid decisions actually have conditions associated with them. So there's a whole lot of conditions that apply to the clearance continuing for 10 or 15 years they're normally granted for. And so if we end up in a no deal on state aid scenario such that these regulations apply, it's probably going to be the case that all of those conditions will fall away. So if we fast forward to January, we might be in a position where the UK has no state aid rules because the EU rules no longer apply. And so for existing aid, the conditions no longer apply. And then for any new, what would have been aid before, actually the UK doesn't have a regime, and so there are no rules on subsidies in place in the UK post 1st of January, which would be interesting, because of course state aid is not just about big tranches of government funding or loans on beneficial terms being given to particular businesses. It's also about overpayment for run-of-the-mill type stuff. And for those that are in the UK, they'll have seen lots of reporting on, for example, the coronavirus contracts that are alleged to have been given to friends of the government, and queries whether there's overpayment involved in those. So there might be some quite interesting allegations and things to think about come January if we do not have state aid rules in place. I think it's fair to say the likelihood is that there will be a deal. I don't think I'm being over optimistic, and that deal will involve agreement on state aid. So where are the two parties at the moment? And I think to us it's clear there is a deal to be done. It's just, as always, a question of political will. So the UK position on a future FTA with the European Union talks about consultation on subsidies with no reference to how those rules against subsidies would be enforced, apart from a ban on agricultural subsidies. And that position, of course, conflicts with what was said in the political declaration. And the EU position equally conflicts with what was said in the political declaration, because what the EU position is, the UK would be bound by current EU rules on state aid and future rules on state aid that are not yet in place. And if it didn't agree to be bound by future rules on state aid, then there would be penalties that would be payable. So I think the two sides are starting from, as in a way is to be expected, their extreme positions. Neither position conforming with what was said in the political declaration, and the question will be, the two I highlighted at the beginning: where will we land on the substance of the rules, and where will we land on how those rules are overseen and enforced? And of course, one of the UK's red lines is that the Court of Justice should not have oversight of the way in which any laws in the UK are applied and enforced. So that would be an oversight and enforcement issue. One of the other enforcement issues that really is a UK only issue was Dominic Cummings, of course, who might now arguably be not part of Boris's inner circle. He was very much against the CMA, so the Competition and Markets Authority, having the power to enforce whatever the substantive state aid rules were in the UK post-Brexit. And I think it remains to be seen whether that position holds. So whether we end up with the CMA in fact holding the reins, if you like, on enforcing whatever state aid rules we have, or whether it will be some other body. And of course, if it's the CMA, then that will pose some quite interesting, potentially political issues as we move forward. The government has flagged that it intends to consult on proposals to implement WTO anti-subsidy and countervailing measures provisions. So in essence, the difference between the EU rules on state aid and the WTO rules on state aid, the EU rules on state aid are triggered purely by dint of any aid potentially being given. The WTO rules are focused on notions of harm, so they're not triggered by the giving of aid, they're triggered by harm being caused by aid, and that, in essence, is the distinction between those two sets of rules. What does it mean for me? Back to you, Nick.
Thanks, John. On the public procurement side, as I've already been saying, I think relatively little change in the short term. I think it's been a question that's been in the mind of those who deal with procurement and interested in procurement, whether the government will, the Johnson government will do what it seems to be doing now, which is effectively rolling the procurement rules forward and joining the GPA, or whether they would take a more radical view. I mean, I know certainly that people like Michael Gove, who's now in charge of the Cabinet Office, has in the past expressed frustration with the procurement rules and suggested that they might be a candidate for significant change after Brexit. But that doesn't seem to be the case in the short term. As I've said, I think there will be an opportunity for for contracts for the health and social sectors, those so-called light touch regime areas, to be restricted to UK operators if contracting authorities wish to do so, which will be quite a big change. And it's also worth noting on that front that if those of you who've been involved in procurement for some time will recall, in the days when we had a distinction in the regulations between Part A and Part B services, Part B services being those services like health and social care and legal services, etc., which were not opened up to full pan-European competition. It was often the case that the advice used to be that it was advisable to tender those on a pan-European basis because there might be a cross-border interest, because as you may recall, there's a lot of kind of European case law which suggested that for those kind of contracts, if there was a pan-European interest, then the European general principles of the treaty would be engaged. Well, my understanding anyways is that won't be the case. So for those services which fall outside the scope of the GPA schedules, which do not include these kind of health and social services sectors, then there's not going to be any sort of overriding provision of treaty principles, which might encourage a sort of a wider competitive tender than the UK only. So that could be, in those sectors, I think a significant change. As I've said, also, I think for those who are involved in procurement disputes, I think there is likely to be greater complexity. The withdrawal legislation itself is complex, and there will be important questions, I think, or questions that arise in the context of disputes as to whether certain EU principles or principles deriving from EU case law should be applied in the UK context. So I think some greater complexity in procurement disputes, but important to emphasise the disputes regime will remain in place until it's otherwise changed. So we'll sort of continue to have standstill periods, notification letters, that sort of thing, as well as automatic suspension of contract making. All those sort of remedies that are familiar to those who work in the procurement field will remain in place. And I will hand over to John for the state aid point on this slide.
Yeah, thanks, Nick. So the big difference with state aid is, of course, the default position is come 1st of January, the rules will no longer apply. So unless there is agreement and a deal and legislation, we will not have state aid rules in the UK post 1st of January, and that's interesting. Well, even if there is a deal, it's interesting. So the UK is made up of 4 nations, and I touched upon the Northern Irish issue before. So the Irish protocol effectively says that the EU rules on state aid will continue to apply in Northern Ireland. Anti-subsidy rules are generally more important and of more use in geographic areas which are federal, and the UK effectively is a federation of 4 nations, and so one could foresee a situation in which, you know, the Scottish government, the Welsh government, Northern Ireland and England, that are potentially different approaches on subsidies being taken, and or post 1st of January subsidies are granted. For example, we all know Nicola Sturgeon likes taking a purposefully different position to the UK government, so she might be tempted to start granting subsidies to particular sectors in Scotland that actually upset the competitive position within the UK. So I think the focus on the state aid rules has rightly and understandably been on the UK position vis-a-vis the European Union, but post 1st of January, I think it'll be interesting to see how whatever rules we have in place, if there are rules, how they play out as between the 4 nations of the UK, and in particular this notion that Northern Ireland will continue to be bound by the EU rules, whereas the rest of the UK, so Scotland, England and Wales, will not be, and then any differences between those nations. So there are private rights in relation to state aid infringements, and by that I mean where state aid has been granted, competing businesses are entitled to bring actions for damages if they think they've suffered loss as a result of unlawful aid. I think those rights are probably time limited as we move forward. I mean, there's never been the same volume of state aid damages cases as there have been competition cases. So you might say that's not that important, but I think it's interesting just to think about, if you are in a business that was being damaged by unlawful aid, historically you have had a right to seek a remedy for that. And I think probably that's not going to be there anymore. I think probably whatever rules we end up with is going to be public enforcement rather than private enforcement that will be the feature. I think that's all I've got to say, Nick.
Yeah, so what should I be doing? I think on the public procurement side, I think the answer is familiarise yourself with the new procurement notices and procedures for advertising tenders. I put a link on the slide, which will be, I think, made available to the UK government guidance on this. I mean, it's very short. The government website is obviously given guidance on lots of different areas that are affected by Brexit. In this case, the note is very short and just simply points you to the new notice procedures and things you have to sign up to and so on if you want to access UK public procurement notices. And I think in terms of actions, that's probably the most practical thing that anyone can do. And on state aid, John, I don't know if there's anything else you'd want to say.
Not really. I know you'll come on to resources. And if anyone has questions, please fire away. On state aid, the Institute for Government has done quite a lot of thinking, and there's a very good paper which I have here, which is Beyond State Aid. Very good. So check out the Institute for Government website if you're interested in sort of thinking through and understanding the options, if you like, for state aid in the UK post-Brexit.
Okay, thanks, John. There's a question function on the webinar thing. So if anyone wants to post any questions, please do so. We'll endeavour to deal with them. There is one question come in about framework agreements under the procurement rules. So the question is, what will happen with framework agreements that were awarded before the end of the transition, and what will happen to call-off agreements after the end of transition? And which is a very good question. The answer is that framework agreements that were awarded before the transition, but which continue after the 1st of January, will continue to be subject to, as it were, the EU procurement rules as implemented in the unamended public contracts regulations. So whether that will have a massive amount of impact in practice, I'm not sure, but certainly there are transitional provisions in place. And similarly, for procurements that are started now or in train now, this is subject to OJU notices and OJU notice, those procurements will continue to be subject to the EU rules. So, for example, a contract award notice would still be published in the OJU, as I understand it, in relation to procurements which were started now, but which finish after the 1st of January. Any other questions? We are here if anyone wants to email any questions or has any thoughts that they kind of occur to them afterwards. Please do feel free to email me or John, and we will get back to you with our thoughts. So I think with that, I would like to thank everybody for attending and for attending the Brexit series generally. John, I don't know if you want to say anything just by way of kind of wrap up on the Brexit series.
Not really. Just I think in both of these areas, but state aid particularly, just because the position is so unclear. If you have an interest, then we're keen to hear from you, discuss what whatever happens means. So thanks.
Yeah. So thanks everybody, and we look forward to seeing what happens on the 1st of January.